Bank owned no trespassing. March 9, 1933, a day that will go down in history and infamy, spoken on a different day but applies more surely for this day, by Franklin Roosevelt. For on this day by the Trading with the Enemies Act and the declaration of bankruptcy by the Congress for the United States, a corporation, the American dream turned into a nightmare. At this point in history, slowly but surely, the bankers proceeded by taking over the federal court system. The taking over of the American court system is now complete as the federal rules can be used in state courts. Congress having never lawfully assembled, after Abraham Lincoln dissolved Congress after the Southern states walked out during the debate over the Civil War, and having never been passed into positive law, now sits outside the Constitution, just as the court system does. This is the reason for the voting registration. For registering, you are given the privilege of voting, and anyone who signs and votes in the federal elections, or any election, are voting as corporate entities, and you are agreeing that Congress has the authority to act from a foreign jurisdiction. The entire court system is now ruled by and comes under the foreign jurisdiction flag. It has a gold rope, a gold fringe around the edge, a gold eagle or gold symbol on top the flag, and now some courts will make a mockery for the United States flag by the positioning in a vertical slope. The powers knew that all commerce is ruled by the law of contracts, better known as the UCC law. Where there is no contract there is no case. The teaching began in school that any contract you signed is a valid contract and that you must fulfill it. This is a good saying as long as it is between two living souls, with all the contract revealed for both parties, and the signatures of both parties thereto. The heretical saying, good credit is the most important thing that you have. A valid contract has 4 parts: 1. Offer, 2. Consideration, 3. Acceptance, 4. The signatures by all parties for the contract. Only the parties that have signed the contract can enforce fulfilling the contract. Without the consent by both parties, a lawyer cannot settle any dispute that may arise from a lawful contract. Our Creator created man. The Creator gave man the right forming government. Man gave government the right for forming corporations. As man has no right nor the ability for ruling his Creator, the government has no right or the ability for ruling its Creator. An illusion is used by the democracy corporate government, and gave man a corporate name and made him a legal fiction by writing his name in all capital letters with the middle name only an initial. The proper name for a living soul is written in upper and lower case letters, the first and middle name being the sovereign name and the last name is the family name. The real name for a living soul is I, me, my, or myself. Government being a creation of mankind is only a piece of paper, as the government, being a piece of paper, could only create a corporation, which in itself is only a piece of paper, neither being able to sign a lawful contract with a living soul. As all governments are corporations themselves, they do not have the ability to sign a lawful contract, for whomever would be so brave, make themselves liable for the execution of the contract, thereby losing their limited liability to prosecution for breach of contract. All corporations then must have someone to speak for them, and the government came up with their own solution, the lawyer, who has been appointed to speak for all corporations in the courts they have created. The government then came up with a solution to the lawful contract, and it is called the unilateral contract, or a one-signature contract. In their own description of the unilateral contract, it says that they were probably written up by a lawyer or a group of lawyers to commit fraud with the intent to extort monies from the signers. The lawful problem with these contracts, aside from the fact that they only have the signature of one party to the contract, is that they have many hidden traps to which the party is not aware of its contents. In many cases, such as bank contracts of signatures for checking purposes, the contract is never shown to the depositor. All contracts pertaining to corporations signed by a one-party participant are fraud from their conception and are used to extort monies from the people. They cannot be enforced except with our permission or consent by assent. From the beginning of mankind, they have the right to contract with whomever or whatever they so choose. The government then set their court system apart from the Constitution and its people, and then invites the people to contract with their court system under the foreign jurisdiction flag, to allow them to settle their disputes. Of course, since a person to the government is described as a corporation, they then treat any living soul, who contracts with their court system, as a corporation, and they are a legal person, a slave or debtor, and cannot speak for itself. The first thing that crosses the minds of parties when receiving a letter from a lawyer, attorney, counselor, esquire stating you have been sued is to run to the phone, call another lawyer, attorney, counselor, esquire to settle the dispute for the two corporations in their court. The judge protecting the lawyers, attorneys, counselors, esquires, and they in turn protect the court, for they are officers of the court. The system is called a legal system, meaning it is legal what they are doing, legal meaning, with your consent. After gaining your consent, it then becomes lawful in their court system for whatever they choose to do to you. Law or lawfulness is constitutional in subject matter, for no law can be enacted, or supposed to be, without an enabling clause from the Constitution of the state or the United States of America. The court does not have a contract with a party until the party gives the judge his/her name. Until that time, the judge is merely an actor in a black robe. The contract the court is trying to get is to contract the party under the foreign jurisdiction flag. See chapter on the flag in the court, as the judges do not file their oath of office into their courtroom, thereby acting under administrative law. Whatever they want it to be. The laws passed since 1926 have all been signed by the President for the British Accredited Regency, EAR, from the state of New York, making all laws come under the bar, so they are nothing more than bar codes, rules, regulations, statutes, procedures for the corporations to follow. The only way you have of making the judge uphold his oath is to file it into the case and restrict him to the law that you want to follow. There are 7 demands for discovery questions to ask all lawyers, attorneys, counselors, esquires. 1. Please produce the legislative act and its implementing regulations that precipitated this cause. 2. Please produce the legislative act that created the office of lawyer, attorney, counselor, esquire. Please give me the address of this office where I may go and get a license for practicing law. 3. Please produce a copy of your oath of office as an officer of the court and where you filed it into public record. 4. Please produce the contract signed by myself, proper name of the living soul, and you, name of the lawyer, in which I agreed to give up my constitutional rights. 5. Please give me your name, address, and phone number. 6. Please give me your bond number and your bonding company. 7. Please send to me an acknowledgement that you understand that you have perjured your oath of office and are committing constructive treason against the Constitution of the United States of America, the state of Texas, and the American peace flag. Under this system of consent, a living soul never has to accept the ruling of the court, but they must object at all times to the action being taken. All persons spending time in prison were sent there by their own words. They did not ask for elocution. Example: Judge, did you receive a fair trial? Answer: yes. The party is just being railroaded. Did your lawyer fight hard for you? Answer: yes. Do you feel that 12 years is a reasonable sentence? Answer: yes. They have just sentenced themselves to prison. This is aided and abetted by the party's lawyer, who has told the party to be nice to the judge in the sentence phase of his trial and tells the party that he or she understands the judge is going to probably give him a 12-year sentence instead of the 50 he could get. The other part of the problem is with the laws, or in today's court the total lack of laws. The charge and intent are lumped together in one charge, and you then cannot plead innocent. You must plead guilty, not guilty. No contest, thereby giving the court jurisdiction. All the courts have been lumped together into one court: administrative/admiralty and civil, contract/commerce. With the advent of your plea, you go under administrative. Any law they want to use to convict you. In order for a law to be construed as law, it must have an enacting clause from the source the law came from, i.e. king, legislature, etc. All laws proceeding from the state legislatures must have an enacting clause, be it enacted by the legislature of the state of Texas. A legislature can only introduce a bill, it cannot introduce a law. It must go through, be approved unanimous by the House, signed by the leader of the House, be approved by the Senate, signed by the leader of the Senate, approved and signed by the governor, and the bill becomes law. Now it is checked against the Constitution to find the enabling clause from it was written. If the Constitution does not allow for the law, then it is void from its inception. Have you ever heard a party can challenge the enacting part of the law or the subject matter jurisdiction of the matter he or she is being tried for violating at any time of the trial or upon conviction? While in prison, usually it is not a law a party is being tried for breaking, but a code, rule, or regulation, or breach of contract. The proper response to "you have been sued" is the redemption process or rejection, returning their contract unsigned in full accord with truth in lending. Never let an attorney or lawyer send you any document without accepting it for value or rejecting, returning without a signature in full accord with truth in lending. They may say anything to you in their first letter and you may think it is harmless. A rattlesnake seems harmless and makes a pretty noise, but is deadly when it strikes. Have you ever heard the phrase "you don't need to respond, do not believe it"? Respond with the redemption process or reject. Return without a signature in full accord with truth in lending. Don't contract with third parties. Tell them to get lost. Tell them that they are fired. We now understand that the government gains power of attorney over us when we are born and they take our birth certificates and make negotiable instruments out of them. We now know that through the Social Security Administration and the issuance of the number, we are recorded as a trust and the living soul is made the trustee of the straw man the trust created. We now have our own power of attorney in fact, and we now know which form to fill out for taxes we have already won.